intentional torts to finish up today, and then we're going to get into the unintentional tort of negligence. So before I finish up the intentional torts, I want to go back to something that's mentioned in your outline kind of up front called transferred intent. Transferred intent means that if I meant to do the act that I did, but it caused harm other than what I intended, that person can still say that I intended the harm that was caused. So an example of that is I throw my shoe at Alexich. He ducks. It hits Geo and hurts Geo. He could sue me for assault and battery. I can't use the defense that I didn't intend to hit him. He can say, no, I'm transferring the intent that you had to hit Alexich with what ended up happening to me. So transferred intent is a principle that I just forgot to mention to y'all on Tuesday. I think fraud was the last tort that we left off with. So in our outline, that takes us to wrongful interference. And wrongful interference could be either with a contractual relationship or with a business relationship. Interference with a contractual relationship is pretty straightforward. Two parties have a contract between them. A third party knows about the contract. A third party causes one of the two parties to the contract to break it. Xavier is employed by me under an employment contract that says he will work for me for 2 years. And Miss Lagun knows about our contract, and she tells Xavier, if you come work for me, I will pay you double. Xavier says, deal, I am breaking my contract with Tebow, I'm going to work for you. I could sue her for the tort of wrongful interference with a contractual relationship because I had one with Xavier, she knew about it, she induced him to break it. Pretty straightforward. Interference with a business relationship is not straightforward because one of the defenses to interference with a business relationship is competition. We're allowed to compete fairly. I'm allowed to advertise a lower price than you. Does that interfere with your business? Yeah. Is it wrongful interference? Not under the law. If I send Xavier, who's working before he quit to go work for Ms. Lagun for more money, if I send him over to Daquan's store to stand out in front of his store and tell people who are coming in, hey, you know that you can get you can get their product cheaper down at Tebow's store, or hey, you know that everything that's served in there is made out of cat meat, or you don't want to come in here. Or if I put him in front of the store to shoot the Orbeez gun at any customer so that they stay away, that might be the tort of interference with a business relationship. Sort of when it crosses the line into becoming unfair is where I would say that you might draw the line. But again, as with all torts, it's always going to be up to the judge or the jury to decide whether or not the conduct meets the definition of the tort. When I say judge or jury, remember that's because in civil cases, you have the right to forego a jury and just let the judge decide the case in place of the jury. So if you have that going on, then the judge would be the ultimate decider of the facts. If you have a jury, then of course it'd be up to the jury. Wrongful interference. That concludes kind of the intentional torts against persons. So that brings us to intentional torts against property. So not only can I commit a wrongful act, a tort, against somebody else, but I could also do it against their property. One way that I might do that is trespass to land. Okay, we're pretty familiar with trespass. This is another example of where we might have a tort that also is a crime. Trespass can be a crime, but it can also be a tort. Trespass can be when you enter on the land of another without their permission, or when you cause something to enter onto another's land without permission. So I could break into Ryan's store in the middle of the night, and he might sue me for the tort of trespass to land because I didn't have permission to do that. Or I could also sit across the street from his store and throw a grenade onto the roof of it that explodes and damages his building. That still might meet the tort of trespass to land because I caused something to go onto his property without permission. You can also be on somebody's property with permission, but overstay your welcome or overstay your permission, and it could become trespass. So I could go in Ryan's store to buy a candy bar. I'm there with permission to do that. But if it comes to closing time and I refuse to leave, I roll out my sleeping bag and tell him I'm going to camp out in his store overnight, then at that point I might be a trespasser. Trespass to land. We can also trespass. So conceptually, we always understand trespass as like walking on or being present somewhere where we're not allowed to be. We can also trespass against things, against personal property. That's not as familiar to us, but there is a tort that's trespass to personal property. If I take Moss's laptop and smash it against the wall, I've committed the tort of trespass against personal property. The elements are when an individual unlawfully harms another's property or otherwise interferes with his right to exclusive possession or enjoyment. I could walk up to him and dump my Coke on his laptop. If that damages his property, that might be trespass to personal property. So that is trespass in a way that we normally don't think of it. There's a tort of conversion that is very similar to trespass to personal property, and they go hand in hand. Conversion happens when I commit trespass to personal property, but then I keep it for my own use. So if I walk up and take Moss's laptop, I've committed trespass against his personal property because I deprived him of the possession and use of the property. It became conversion when I kept it and used it for myself. So two torts. Remember, when it comes to tort law, and we want to sue for a tort, we've often got a menu to choose from. It's not only one or the other. One act or one set of circumstances could constitute multiple torts. We're going to see that in our example. We're going to go through some fact pattern that'll show that in a second. If I just took Moss's laptop and slammed it against the wall, I probably have not committed conversion because I didn't keep it and use it for myself. So again, trespass to personal property can morph or cross the line into another tort of conversion if the wrongdoer keeps it and uses it for himself or herself. Those are intentional torts against property. The final one is disparagement of property, and that is the equivalent of defamation, but instead of harming a person's reputation, we're harming the reputation of the product. So my example to you, I used an example Tuesday of saying that you all owned Guthrie's, and I said that you sold cat meat instead of chicken fingers, or that your chicken fingers were made out of cat meat. That defamed the reputation of the owner, but it also disparaged the product. So I may have two torts there when I advertise that Guthrie, or when I make the statement that Guthrie serves cat meat for chicken fingers. You may get me for defamation against the owner and operator, but you also could get me for disparagement of property. Again, that's akin to defamation, but against a thing instead of a person. Disparagement of property. So pull up then, if you will, look on your Cougar View and pull up down below the document that's titled Torts Examples. Do y'all see something named Torts Examples? All right. And when you pull that up, you should see a one-page fact pattern that begins, Johnny owns a convenience store. Does anybody not see that? All right. Pull that up, if you will, and then I'll give everybody a minute or two to read through that. While you're reading through it, let's assume that everybody from Alexich over on this side is Rusty's lawyers. Everybody from Mr. Snow, did I say that right? Say, I didn't get it close. From you over are Johnny's lawyers. All right, and y'all take a couple seconds to read that. How did I mess that up? All right, anybody still reading? Raise your hand. All right, y'all are good, quick readers. So I'm going to start with, we're going to go one sentence at a time, and we'll go back and forth. I'm going to start with, last Christmas, Johnny snuck onto Rusty's roof at night and swiped Rusty's Christmas decorations, which Johnny then displayed on the roof of his own store. So Rusty's lawyers, what torts do you want to sue Johnny for from that sentence? Who said that? Gio, I didn't see you. All right, trespass. What kind of trespass? Which trespass? Well, we have trespass to land and we have trespass to personal property. All right, what constitutes trespass to personal property here? When Johnny did what? When he took the decorations. All right. And because in taking the decorations, he deprived Rusty of the ownership and use of his own property. Right? Good. Could we also do trespass the land? Tell me why, Michael. He went over there when he wasn't allowed to. He went onto Rusty's property without permission. I would say yes, you got trespass to land and you have trespass to personal property. We might have another. Conversion. Why? Tell me why. And he used them as his own. So when we did have the trespass to personal property, but when he took them to use as his own, that crossed the line into conversion. Good. Y'all got 3 torts out of 1 sentence. Trespass to land, trespass to personal property, and conversion. Johnny's lawyers, y'all have any defenses so far to those? Probably not. I mean, I can't really think of any good ones. All right, Johnny's lawyers. Just last week, Rusty rented a plane to fly over town with a banner that read, Johnny's Go-Go sells hot dogs made from cats. I really need to come up with a new example, don't I? We keep going back to cat meat way too often. Johnny's lawyers, starting with Saheed over. What do y'all want to sue Rusty for? Defamation. All right, tell me why, Xavier. Is it slander or libel? Libel, why? Because it's written. That's right. Good. All right, it's defamation in the form of libel. What are the elements of defamation, though, that we have to meet? You got to have a false statement of fact. Do we have that here?
Yes.
Okay. What's the false statement of fact? All right, that his hot dogs are made of cats. So we're assuming that his hot dogs are, in fact, hot dogs and not cat dogs or hot cats, right? The false statement of fact has to be published. Did it get published in this case? How so? Yeah, it was flown over town in writing. Good. And it has to tend to be harmful to Johnny's reputation. That's harmful to Johnny's reputation. Any defenses there, Rusty's lawyers, that you guys have? No. What if you had to make up a defense? Is there anything that you could say? I didn't say it had to be a good one. What about, I'm spitballing. That's not serious. Everybody knows that I was joking. There's no such thing as a hot dog made out of cat meat. That's just not a thing. What about Johnny's reputation is so bad that there's no way we can make it worse? I don't know. I'm just, I'm spitballing on that, but there aren't really good defenses to that. In retaliation, Johnny has Rusty's One Stop Sucks t-shirts printed and he gives them away. So Rusty's lawyers, are y'all interested in any torts from that sentence? Maybe defamation. What's the problem with defamation here? Johnny's lawyers, y'all get sued for defamation for those t-shirts. What's your defense? It's an opinion. Good, Horner. It's an opinion. They weren't flying over town. They were published. They were harmful to the reputation, but it was not a false statement of fact. All right, so this escalates. Rusty is enraged. He marches across the street to fight Johnny. They square off, and Johnny swings at Rusty and misses, instead hitting Ronnie. All right, Rusty's lawyers. Johnny took a swing. Any torts you want to allege for that? Assault, because why? Good. Good. There was a threat of offensive contact. What else do we have to have for assault? Not just the threat on Johnny's part, but what on Rusty's part? You got to have fear of harm from the threat. So good. All right. Nobody didn't assign anybody to be Ronnie's lawyers. Do you have a question, Janeway?
It needed to be unjustified. So
good.
Be able to prove that it wasn't justified for him to take a
Okay, that's a good point. It needs to be unjustified. So one of the parts of the definition is unjustified. So what do you say then as Johnny's lawyer? How could it be justified?
Well, it seems as though Rusty is presenting an immediate threat to Johnny's well-being.
All right. That is a valid defense. Rusty's lawyers, what do you say about that?
Couldn't we say the same thing?
Could you say the same thing?
Rusty came to Johnny.
Yeah, Rusty. I mean, all right. I like this. So Rusty's lawyers say, well, we could say the same thing. Maybe we were acting in self-defense. Maybe we were justified. Johnny says, yeah, but you came to me. Johnny swung first. Good. I like it. I like the way y'all are thinking. This is exactly how you should analyze the problem, to be able to see both sides of it. Pretend that you are Ronnie's lawyers for a second. You got hit when Johnny swung at Rusty and missed. What might you sue for him for, Saeed? Say that again? Conversion? Not thinking of conversion on this one because this doesn't involve personal property. Battery. The battery is the what, Michael? Him actually getting hit. The offensive, unwanted touching. Ryan brought up a great point. Also got to be unjustified. What you got? Intentional infliction. What would you have to show for that? That there was outrageous conduct that caused emotional harm. What do y'all think about that? Yep, you think this is a good intentional infliction of emotional distress claim? Johnny's lawyers, what would you argue against that claim? Intentional infliction of emotional distress against Ronnie. What? I mean, we were fighting, right? Is that the defense would be that might not be outrageous and extreme conduct. These guys were provoking each other. That might be the defense to that. I'm not sure. Ronnie knew what it was going on. Yeah. Probably not a strong case for intentional infliction, but I like that you bring that up, Mr. Edmond, because these things are not black and white. You can allege these things if you think you got the facts to prove them. Might as well throw it in there. I think somebody said battery.
I did say battery, but it could also be assault.
Could also be assault against Ronnie. What if I raised the defense that I didn't intend to hit Ronnie?
You intended to hit someone.
And so what principle might you invoke? The transferred intent, right, okay. So one more element that we have to prove for assault on Ronnie. He has to be, the swing has to create fear that in Ronnie that he was going to get hit. That probably happened just as soon as he saw that it missed Rusty, right? And the fear became, that would be the argument there. All right, so we've got, did anyone say assault against Rusty? Did we say that? What do you think about assault against Rusty here? Anybody? Ethan, was that you? No?
Be excused.
Excused? Oh, well, that's right. Ryan's sticking with the argument that it was justified. Rusty's lawyers, you may make the argument that it was assault if the swing caused Rusty to fear being harmed, even though it didn't hit him. So we've got a potential assault on Rusty. We've got a potential assault on Ronnie and a potential battery on Ronnie. All right. Johnny then kicks Rusty in the head. Rusty's lawyers, what do y'all want to sue him for there? Assault and battery. That's a good one. Maybe intentional infliction. Oh, that's a little bit more of a stretch. Assault and battery for sure. Rusty bites Johnny's ear. Johnny's lawyers, what do y'all see there? What torts do we have here? They just sued you for assault and battery for kicking him. Go back right back with assault and battery for biting the ear. I could see that. Later that week, things settled down. Rusty posts an unflattering poster of Johnny in the store window right next to another poster that says, "Beware of coronavirus." I wrote this like during COVID. So assume that coronavirus is something that's super serious and fearsome. Well, I mean, it was. I'm not downplaying it. We just look at it a little different today than we did. Is that defamation?
Maybe fraudulent misrepresentation.
Why is it?
Because it's not directly stating.
Okay, we don't have a false statement of fact. So that rules out defamation. Fraudulent misrepresentation, we've got to have a misstatement of material fact that causes someone to buy a product, purchase something. So we don't have that going on.
Well, maybe you're trying to drive business away from the store across the street to your own.
Okay. Maybe you hadn't really thought of that one, but you might make an argument then for interference with a business relationship. Possibly, if that is affecting Rusty's customers. Maybe. That's possible. What else? There's an invasion of privacy tort in there that we called on Tuesday false light. Remember, that is basically, it's not the same as defamation because we don't have a false statement of fact, but it's defamation kind of by inference. Like we want you to infer that Rusty is full of the Rona. False light. Even though Rusty's best employee, Beth, has a contract with Rusty, Johnny entices her to break her contract with a promise of doubling her salary. Rusty, do y'all have any claims from this sentence? Rusty's lawyers. Intentional interference with contractual relationship. Good. Johnny hacks into Rusty's online dating account, copies X-rated photos of Rusty and Ronnie's wife, which Johnny posts on social media. All right, stop there. Rusty's lawyers, do y'all have any claims from that sentence? Invasion of privacy, for sure. I think that's a pretty strong case for invasion of privacy. Ronnie's wife is so traumatized that she suffers from PTSD and all of her hair falls out. So now you are Ronnie's wife's lawyer. Do you want to bring any tort cases against Johnny? And if so, what for? Intentional infliction of emotional distress. That's a good one. What's your best piece of evidence for intentional infliction here? Say that again, Gio. He posted, yeah, that the actual smoking gun, right? But you're correct. Let me ask a better question. For Ronnie's wife having to prove harm, what's her best piece of evidence? Her hair falling out. Good. That's a tangible manifestation of that. And if she had a doctor to come and testify that he or she diagnosed her with PTSD, that's another good manifestation of the emotional distress.
You also do invasion of privacy?
Could you do invasion of privacy? That's a good question. Let's think about that. I think it's a harder case for Ronnie's wife to make out because I'm not sure she had the expectation of privacy in Rusty's email account. Is why I think that's a harder case.
Probably do trespass to personal property though, right?
Ooh, trespass to personal property. That's a good one. I mean, the pictures are personal property. Johnny took them. I don't know that he deprived her of the ownership of them, though, or that he damaged them. But I like the way you're thinking, because that illustrates kind of how tort law works. Remember, we can have one set of facts or circumstances that could become multiple torts, could also become crimes. But in the realm of tort law, you see how just a few things or one act can result in multiple examples of tort liability. All right. Those were all intentional torts. I want to move now to the unintentional tort of negligence. So negligence is probably the largest area of tort law. I don't have the statistics for it, but I would think that. So we don't have a law that says when you're walking down the hallway, you have to walk in a careful way so that you don't hurt other people. We don't have a law that says if you're going to throw things, you need to make sure you don't throw things at other people and hurt them. We don't have specific laws that spell out all the ways that we could be careless and cause harm to other people. But we do have a law that says every person has a duty to act carefully in whatever they do. This is the tort of negligence. Everybody has to be careful in whatever they do. All right, so negligence then is when we breach our duty of care, when we don't act carefully in everything that we do. We might have committed negligence. Negligence has 4 elements. One is that there has to be a duty of care. There has to be a breach of that duty. The breach has to actually cause harm. And then there has to be some damages that result. So, real life example of that. I'm driving down University Avenue on the way to class. I am looking at my phone and not paying attention to the road. I don't see that Grace has stopped in front of me at a red light, and I rear end her car. Is there a duty? Do I have a duty to drive carefully? Yes. So we got that part of it. Did I breach that duty by looking at my phone instead of the road? Yeah. Did my breach of the duty cause her the accident? Yeah. Did she have damages? Yeah, let's assuming her car's hurt. If I am driving down University Avenue looking at my phone and I look up to see her stopped, and I slam on brakes, and I stop 1 inch from her bumper, do I have a duty to drive carefully? Did I breach that duty? Did I cause harm? No. I don't have a negligence case there. If I am driving down University Avenue, looking at my phone, and I look up, slam on brakes, and I do end up touching Grace's bumper, but I don't cause any damage to her car. Did I have a duty to drive carefully? Sure. Did I breach it? Yeah. Did I cause my car to run into hers? Did my breach cause that? Does she have damages? No. So we don't have negligence. Got to have all 4 of those things in order to make out a negligence case. When I talk about there being a duty of care, the duty that every person has to behave carefully, we measure that by the reasonable person standard. What would a reasonable person be expected to do under the circumstances? Do we expect the reasonable person to watch the road while they're driving? Sure. Do we expect the reasonable person to drive 20 miles under the speed limit, keep 2 hands on the wheel, and lay on the horn anytime they see a potential danger in the road? No, we're not. In other words, we don't have a duty to drive that carefully. Our duty of care is that of a reasonable person under the circumstances. Incidentally, who would decide in a tort case for negligence whether or not the person had a reasonable duty of care? Who makes that decision in our lawsuit? It's going to be up to the judge or the jury. Right. All right, I want to focus on causation for a minute, this causation element. Assume that I have a grenade in my backpack and I accidentally pull the pin on it, realize what I've done, throw it over there, tell y'all, look out, this grenade, I pulled the pin on this grenade. You all, in fear of the coming explosion, get up, rush out of the room. In rushing out of the room, you throw the door open, you knock over a person who's just walking down the hallway, you run over students who are in the hallway on your way out of the building, and you injure them. There was a guy that got hit by the door and knocked out so hard that he thought he was dying, so he calls his mother, tells her that this is it, goodbye. She has a heart attack as a result and gets taken to the hospital where the doctor operates on her leg by mistake instead of her heart. Did my carelessness with the grenade cause all of that? It did. It was the actual cause of everything that happened on the chain of events. Because if I hadn't done it, none of the consequences would have occurred. So my carelessness with the grenade was the actual cause of everything all the way down the line, including the doctors screwing up the surgery. Okay? But in negligence law, we draw the line for purposes of what the wrongdoer is responsible for. We draw a line somewhere of what I am and am not responsible for, all the ensuing consequences. We call that proximate cause. So when we get to the element of causation in negligence, my carelessness has to be the proximate cause of the person's injuries. So let's walk through that let me tell you how we measure proximate cause. We measure proximate cause by foreseeability. The simple question of, was it foreseeable that the harm would have occurred from the wrong that I did? So let's walk through my example. Was it foreseeable that if I mishandled the grenade and you all saw that you all might get up and run out of the room? Absolutely. Was it foreseeable that in running from the grenade, you would open that door as fast and as hard as you could? That's foreseeable. Was it foreseeable that in your fear and running from the room and slam open the door, that somebody might get hit on the other side of it? That's foreseeable. If I'm going to cause an explosion from a grenade, then there's going to be a stampede. That is the exact foreseeable result of my conduct. People might get run over. Was it foreseeable that one of the injured people might call a relative to tell them about being injured? I mean, yeah. We're getting a little bit farther. We're getting a little bit fuzzier on foreseeability, but that's foreseeable. Is it foreseeable that it might scare the person that got called so much that they have a heart attack? I mean, that's getting a little bit harder and a little bit more tenuous, right? Is it foreseeable that by throwing a grenade in the classroom, you guys are going to stampede out, injure people who are going to call their mother, who's going to have a heart attack, who's then going to go to the hospital and get operated on the wrong body part? That's not something that you would say is foreseeable as a result of me setting off a grenade in the room. So you see that at a certain point, the law draws a line for legal responsibility. That's called proximate cause. I still caused the sequence of events that resulted in the lady's leg being operated on wrong. I was the actual cause of that. But I'm not going to have legal liability for it because it wasn't the proximate cause. There was not a direct enough link between the wrong that I did and the foreseeability of the harm that resulted. So actual cause and proximate cause are two different things. Actual cause is, would the result have happened but for the conduct? Proximate cause is, was it foreseeable enough that we need to assign liability to the wrongdoer? Causation. Any questions on negligence? All right, I'm going to talk for a second then about some defenses to negligence. So, for purposes of this discussion, we can assume that there is negligence, that the four elements of negligence have been met. There was a duty of care, it was breached, it was the proximate cause of the injuries, and there were damages that are compensable. But the actor might have valid defenses to their conduct. One is assumption of risk. A person knew of the risk and voluntarily assumed it. I have a grenade. I pull the pin on it, and Ethan decides to come up and take the grenade and look at it. it explodes. He sues me for negligence. I have a duty to not have explosive munitions that are active in a classroom. I breached that duty. It caused his injuries. He's got damages. There's negligence for sure. But I might use the defense of assumption of risk. Dumbass should know better than to come up here and grab an active live grenade. Right? He assumed the risk that it might explode. He knows better than that. Assumption of risk. I don't know that that's a great example. I've got a chainsaw that's defective. There's something wrong with the chain. Ethan asked me if he can borrow my chainsaw. I tell him yes, but the chain's messed up. You see how it's not secure on the blade. He's like, "That's fine. I'll borrow it anyway." He ends up getting cut because the chainsaw's not working properly. He sues me. I've got a duty. Maybe I guess I rent chainsaws. It's a business. So I've got a duty to rent chainsaws that are not going to hurt people. I breached that duty. It caused his injuries. But I might use the defense of assumption of risk. I told him that this chainsaw is defective. So he knowingly and voluntarily assumed the risk when he intentionally used it knowing all that. That could be assumption of risk. So that could be a defense to negligence. Contributory negligence and comparative negligence are defenses. I do want you to know about those. So they're similar, is why I'm grouping them together. Contributory negligence is when the defendant has been negligent, but the plaintiff was also negligent. So let me think of a good example of that. I'm driving down University Avenue, looking at my phone and not paying attention to where I'm going, and Miss Horner is stopped in the middle of the street for no good reason. There's no stoplight, that she's just stopped. No brake lights, just sitting there in the middle of the road. I look up from my phone, realize I'm going to hit her, crash into the back of her. She sues me for negligence. She's got me. I've got a duty to drive carefully. I breached it. I caused the accident, and I caused some damages. But I might also raise the defense that she was negligent too. She's got a duty to operate her car carefully, and the reasonable person in those circumstances would not stop in the middle of the road for no reason. Her breach of that duty contributed to the accident, and I had some damages. Okay, so that might be a defense that I would raise. If I do raise that defense, comparative and contributory negligence work in this way. Contributory negligence, some states will say that if the plaintiff was at all negligent themselves, they can't recover from the defendant who was negligent. So if we're in a contributory negligence state and Miss Horner sues me, she cannot recover because she was a little bit at fault. If we're in a comparative negligence state, which is the majority of states, comparative negligence allows the jury to apportion fault between us, assign fault between us, and then reduce the award by the percentage of negligence. So let's say that in our case, the jury says Tebow was 80% at fault in this situation because he wasn't looking where he was going. But Ms. Horner was 20% at fault for being stopped in the road for no reason. She had $1 million in damages. We're going to reduce her damage award by the 20% that she was negligent. That's how comparative negligence works. Comparative negligence states usually also will say you have to be under 50% at fault to recover. In other words, if the jury decided that I was 20% at fault, but she was 80%, then she's just out of luck. That's one modification kind of comparative negligence. But those are both defenses to negligence. Contributory negligence, remember, where you're just out of luck if you were even a little bit at fault, that's a lot harsher result than comparative negligence. Comparative negligence is much fairer in the sense that it's going to let the jury try to apportion fault in the correct percentage and then modify the award accordingly. There's another defense to negligence in your outline called superseding cause. A superseding intervening force breaks the connection between the wrongful act and the injury. Let's assume that in my grenade example where you all stampeded out of the classroom and ran over one of your fellow students, who then we called an ambulance to come get him, and the ambulance came and got him, and on the way to the hospital, the ambulance is blown up by alien space lasers. Okay? I might raise the defense then of superseding cause. In other words, that had nothing to, it was not foreseeable that space alien lasers might come out of and blow up the ambulance. That was a totally different cause than what I did. Yes, I put that chain of events in motion. My negligence did start that chain of events, but there was another superseding cause that came in, and that really should be at fault more than I should. That's not a very common defense, but it is a defense. All right, I want to talk about the Dykstra case. We got time. So, Dykstra case involves the tort of defamation. This is a real life case, was decided in 2020, so it's relatively recent. And it involved two former Major League Baseball players who were teammates back in the 80s on the New York Mets. So, is this a civil or criminal case? What do you say, Mr. Edmond? Everybody says civil. Good, I like that. Everybody answered. It's a civil case. What area of law are we in? Are we in criminal law or tort law? Tort law, that's right. Who's the plaintiff? Lenny Dykstra is the plaintiff. Who's the defendant? Ron Darling. And what is Dykstra's claim? What is he suing Darling? What tort is he suing him for? Right. Defamation, good. Is it slander or libel? Libel because it's written. Very good. All right. And then if you notice, in this case, it says it's in the Supreme Court of the state of New York for New York County. That is true. It's just confusing because we think of Supreme Court as like the highest court in the court system. New York State got it all backwards. It's their equivalent of what we would call a superior court, kind of the entry-level trial court. Just not going to test you on that, but just pointing that out. Seems like a higher level court than it is. But this is the entry-level court where Dykstra brought his lawsuit. And the gist of it is that Dykstra wrote a book and told a story about Dykstra, claiming that Dykstra yelled just horrible racist stuff at the pitcher from the other team during the World Series. Dykstra sues Darling saying that's defamation. you've made a false statement of fact. It harmed my reputation. It got published to other people, and I have damages as a result. Darling has an unusual defense to defamation. Usually we think of good defenses to defamation being it's true or it's an opinion. Those are our normal go-to defamation defenses. But he raises the defense of a libel-proof plaintiff. What is a libel-proof plaintiff? What's the idea behind that? Anybody? Ryan?
Character is so bad that you can't make it any worse.
Right. Yes, I said that about him. And let's assume that it was defamatory. So what? His reputation is already so bad that I can't make it any worse. What was Dykstra's response to that argument? You're Dykstra's lawyers. What do you say to that? His reputation wasn't that bad. That's a good one, Xavier. What else? Yeah, I mean, okay, maybe he had a bad reputation, but this still makes it worse. Dykstra's lawyers made that argument. They also made the argument of, okay, when we say a person is bad, like what constitutes that? I mean, if we see somebody has a long criminal record, we can pull that out and prove it. But how do we prove? Where's the record that shows that Lenny Dykstra is bad? That was part of their argument. Yeah, they put in a lot of evidence of it, didn't they? So we get to the part of the case where they discuss the relevant law. And New York, this court's telling you the New York definition of defamation, which should be familiar to you. A false statement tends to expose the plaintiff to public contempt, ridicule, aversion, disgrace, induce an evil opinion of him. And it causes harm. The court talks about why we have defamation. Defamation actions require courts to balance the individual's interest in guarding his good name, his reputation, with the interest of the speakers that the speaker has in exercising First Amendment freedom of speech rights. The court goes on to tell you that discerning opinion from fact is often a complicated process. It's not, when we talk about things like hot dogs made of cat meat, that's either true or false. Whether someone is a bad person, whether someone's made offensive comments is not as easy to discern. So then the court goes on to discuss the application of the law to the facts of this case. And they conclude that Dykstra did have a pretty bad reputation already, and that what Darling said really didn't do any extra harm. What do y'all think about that? Anybody have thoughts on the way the court looked at this? Agree or disagree? Agree. Who says agree? Why? Agree and why?
I mean, MLB players, especially if they're pretty good, I mean, they have a pretty high social status, and I'm sure they definitely have heard about it. You know, I mean, I get he's a teammate, but like they said, his identity was so bad, I mean, it couldn't make it any worse in any way possible, it seemed like.
So the argument, you can see where some people might have a bad reputation, but you could still make it worse. But in this case, you really couldn't make it worse. All right, Edmund, what do you say? Not enough evidence? So it might have made a difference if there was actually something to measure it against, like if there was a video and you could have seen whether or not what he said was really that bad, but there wasn't. Ms. Pepito, I think you raised your hand. Did I skip you?
I agree, and I guess I agree with the court because the evidence that they provided, like the focusing about the magazine articles and stuff, like other magazines mentioned that he was kind of like mad instead of happy.
All right, good. Good thought. Yes, sir.
I would disagree.
All right, we got a disagreement. Good. Tell me why.
It seems that in which one was the one that was the bad character, Dexter?
Yep.
Seems that Dexter had brought evidence to support that there was specific damages that were related to that book.
In other words, you'd be more sympathetic to his argument that he could actually show that things got worse for him as a result of this book.
It seemed like he was able to quantify that.
So if he was, that would be something that you would weigh in.
Yes.
I think that's a good point. Can you think of anything that we could say about Dykstra that wouldn't fall under this libel-proof plaintiff doctrine? In other words, what could you think of that we could say about him that would be worse than what was out there already? Can anybody think of something that would be worse? Yeah.
Something in a new category.
Something in a new category. Good. What about if Darling wrote falsely that he raped children? If you're Dykstra's lawyers, then do you think that I mean, he might not be libel proof from that. If I'm his lawyer, I think that's a good argument. Yes, he's got a bad reputation, but not of that. Different category, more severe, not the same nature of allegations. People look at him way differently. Yeah, I mean, like, yeah, he's a rascal, former ball player, has gotten in some trouble. That's a lot different than a, sexual predator of children. I can see where maybe he's not libel proof from everything. All right, on Tuesday, we are going to go over some negligence scenarios. We're going to talk about the Willingham case, and we're going to talk about products liability and the McDonald's versus Liebeck case. So you need to read Willingham and McDonald's for Tuesday. And we won't have class next Thursday, so your quiz on torts will go live next Tuesday right after class. See y'all then. If you came in late, let me know. I got you. I think that was. Oh, I did not get you. I got you, Gio. Let me see. Melanie, were you here Tuesday? Okay. I just want to make sure I didn't mess that up. Thank you for saying that. I would not have gotten it. Bill Buckner's legs, I think. Wasn't it?